When courts reward what they could stop, the results are always tragic. We do not always know every fact when a tragedy hits the news when it comes to family law, and we should not pretend we do. But sometimes the broad pattern is familiar enough to discuss honestly. A parent has a child custody or parent time court order. The other parent blocks access. The excluded parent hires lawyers, files enforcement motions, waits, pleads, and keeps trying. The court issues warnings, orders make-up time, recommends counseling and therapy, maybe imposes a small sanction, then waits again. Meanwhile, the children lose a parent in real life while the paperwork says otherwise. That is not a co-parenting communication problem. That is not a scheduling misunderstanding. When a parent deliberately, repeatedly, and systematically cuts children off from the other parent in defiance of court orders, that is emotional and psychological abuse of the children, and perhaps even of the parent. Courts have been far too reluctant to call it that, punish it, or remedy it. The usual excuse for failing to act decisively is that changing custody or removing children from the obstructing parent's home would be disruptive. And yes, it might be. Nobody seriously denies that. But the question is who created the disruption. The trauma is not created by enforcement. The trauma was created by the parent who isolated the children, manufactured dependency, and made the other parent seem unnecessary, dangerous, or irrelevant. A doctor who resets a badly healed fracture will cause pain, but the pain is part of treating the injury. Refusing to reset the fracture because treatment hurts is not compassion. It is negligence with better manners. Courts do something similar when they allow an alienating parent to use the damage he or she created as protection against consequences. The children are too bonded to the offending parent, some might say. The transition would be hard. We do not want to destabilize the children. But that so-called stability may be nothing more than the last bad arrangement the court allowed to harden. Every time a court treats the third enforcement motion like the first one, it sends a message. This conduct has no real cost. Every time it orders more make-up time instead of modifying custody, it tells the offending parent that delay works. And the children learn the same lesson. They learn that court orders are optional when one parent is determined enough to ignore them. Utah courts already have the authority to consider the child's best interests and to modify custody when a parent's conduct warrants it. No magical new statute is required. The missing ingredient is often not the law, it is will. Sustained willful documented denial of court-ordered parent time is not a close case. It is abuse. Courts that refuse to treat it as such are not protecting children from disruption. They are protecting the parent who caused it. And when systems reward what they could stop, the results are not merely inefficient, they are tragic.